The John Magnier and Barne Estate High Court case was supposed to start, their civil trial was supposed to start Thursday of this week. And yesterday was Friday, and the judge has now adjourned it until April because of issues that were raised by the Magnier side about the discovery process. The discovery process involves each side exchanging relevant documents which are not privileged with the other side. And it allows both parties to identify, I suppose, the evidence and the issues and the facts and so on, and it allows the judge to see exactly what's what in terms of determining what happened, what the facts were, etc., and what the evidence is. So documents and so forth are very, very important as part of that discovery process. It's not just documents, though, that might be discovered. I mean, it could be electronic records, physical records, paper records, notes of meetings, attendances, telephone conversations, etc., etc. The point is that the case has been now put back until April by the judge because the judge agreed with John Magnier's side that the discovery process has been inadequate basically by the defendants, the Barne estate people. And the reason for that is because there has been some documents or some evidence which Magnier's side claim should have been disclosed, which wasn't disclosed or discovered. And for that reason, the judge has put the case back. But leaving aside the discovery question and the discovery process and so on, and the procedural aspect of this case, many people have contacted me and have left comments online on the likes of YouTube and elsewhere about this case, on LinkedIn, about this case. And they've contacted me by direct message as well. And they've asked me about how could Magnier win, because it's in all correspondence leading up to the execution of a contract. It's in all correspondence marked without prejudice, subject to contract and so forth. And therefore you can't rely on what was said or done in the lead up to the signing of a contract, the execution of a contract. And up to that point, up to the point at which a binding contract comes into place, then everything is without prejudice and simply cannot be relied upon. And that's the whole purpose, that's the whole idea of without prejudice communication in property transactions or in litigation or in any form of law, quite frankly. Some commenters have put forward the idea that if Magnier was to win this case, for example, it would throw over the whole idea of without prejudice communications, and it would set aside what has gone on for centuries, quite frankly, in relation to the forming of a binding contract, the formation of a binding contract. It would be set aside if Magnier was to win this case. Now, they're asking me, what is his game plan? How can he possibly win, etc., etc. And I have to honestly say, I have no idea. Simply because I haven't seen the evidence. I don't know the evidence. I don't know what the evidence is. I don't know what evidence exists or might exist or is claimed to exist. However, we did get a glimpse into it yesterday in the High Court when the judge did adjourn the case back to April. And that's because, as I say, the dissatisfaction with the judge or by the judge with the discovery that's gone on to date. And one very important factor has come out in the reporting yesterday, and this reporting that I'm going to be relying on is from the Irish Times and it's by Fiachra Gallagher. But one very interesting thing came out is that Magnier's side claimed that they had an exclusivity agreement for 1 month from, I think, the 31st of August 2023 to the 30th of September 2023. In other words, for 1 month, Magnier's side had an exclusive agreement with the other side in relation to buying the place, doing a deal. And I think it is, or may be, Magnier's case that the other side breached this agreement, and they breached this agreement with the encouragement of the ultimate purchaser, Mr. Maurice Regan, who apparently is a property billionaire. But Magnier's side are saying that this exclusivity agreement was breached, and they have this agreement. It was an exclusive agreement, and it provided that during that particular period of time, that month, that the Barne estate side could not entertain or encourage or invite any offers for the property. In other words, the exclusivity aspect of it was for Magnier to do a deal or try to do a deal. Now, that's one novel aspect of it. The other prong, apparently, of Magnier's argument, Magner's case, is basically that he had a deal done. Okay, so on the one hand, he had a deal done, and the parties knew and agreed what the deal was. And secondly, he says he had an exclusivity agreement in any case, and that it was during the exclusivity agreement period that Mr. Maurice Regan stepped in, or was invited to step in, or did step in, and basically encouraged the Barne estate side to forget about the agreement and do business with him. Now, that appears to be, on the reading from a very, very brief recording, or a very brief report yesterday, a report from Fiachra Gallagher in the Irish Times about the discovery process. So it will be a fascinating case when it does unfold. It's supposed to last for 3 weeks. It remains to be seen whether it does or doesn't. It remains to be seen whether it gets off the ground or is settled or not, but it doesn't look at this stage like it's going to settle, and clearly both parties have the resources, the money. But some interesting things came out yesterday in the reporting as well, and that is the allegation by Magnier's side that there is, quote, a dark force financing the Barne estate side of the litigation, and that dark force, they are alleging, is Mr. Maurice Regan, who bought the place, the Barne estate, 751 acres, for 22.5 million euros or something like that, whereas Magnier claims he had a deal to buy the place for 15 million. Let's have a look at the reporting from the Irish Times and just the interesting aspects of it. Yeah, lawyers for John Magnier claimed yesterday that there is, quote, a dark force funding the Barne estate litigation. John Magnier has taken action, legal action, that the Tipperary lands near Clonmel, the Barne estate, should have been sold to his family rather than to Maurice Regan, the construction man. And John Magnier claims that the owners of the Barne estate in County Tipperary have basically reneged on a purported deal to sell the estate to him for 15 million. They're claiming that the US-based construction billionaire Maurice Regan is funding the owners of the Barne estate in their defence of this High Court action taken by Magnier. Senior counsel for John Magnier have claimed that recently discovered documents evidenced Mr. Regan bullying and threatening custodians of the County Tipperary estate and inducing a breach of an exclusivity agreement that Magnier says was in effect following the purported deal. All these claims obviously are denied by the Barne estate people. Martin Hayden, senior counsel for the defendant, said that the allegation that Maurice Regan was financing the proceedings was, quote, an outrage, and there was no evidence before the court to support it. The hearing was due to begin on Thursday. Yesterday, Friday, it has been adjourned for several weeks to allow the defendants to remedy what he described as their incomplete and grossly inadequate discovery of documents. So clearly Magnier has some argument there in relation to the discovery issues, problems, and clearly has won that argument because the judge agrees and says that the discovery by the defendants has been incomplete and grossly inadequate. Magnier is claiming that there was a deal struck on August 22nd, 2023 at Mr. Magnier's Coolmore stud. They also claimed that they had an exclusivity agreement stipulating that the estate would not permit its representatives to solicit or encourage any expression of interest, inquiry or offer on the property from anyone other than Mr. Magnier, and they're saying that was in effect from the 31st of August 2023 to the 30th of September 2023. The Barne defendants, they say that there was never any such agreement, and subsequently they agreed to sell it for 22.5 million to Mr. Regan. He's the founder of a New York building firm, JT Megan. Mr. Regan is not a party to the case, but as I say, John Magnier's side are claiming that he's a dark force who's actually financing the defence. Mr. Gallagher, senior counsel for Magnier, claimed that the defendants refused to provide information on foot of queries about Mr. Regan, whom Mr. Gallagher described as a dark force, allegedly funding the proceedings. He said that we have repeatedly asked for the confirmation that Mr. Regan is funding these proceedings, Mr. Gallagher said. Mr. Hayden, Martin Hayden, senior counsel, said he was not obliged to engage with Mr. Gallagher's allegations. He said that if Mr. Gallagher had the remotest idea a non-party was funding the litigation, he was absolutely sure with the resources at his disposal we'd have a motion to strike out the proceedings. In other words, Martin Hayden is saying that if there was any truth to that, Magnier has enough resources to bring an application to strike out the proceedings on the basis that it was being funded by a non-party, that is Mr. Regan. Mr. Gallagher also claimed that a document of about 60 pages of typed notes written by John Stokes, he's a Tipperary-based estate agent who was present at the August 2023 meeting at Coolmore Stud, not only set out the terms of the deal for the estate as Mr. Magnier has pleaded, but it also showed Mr. Regan inducing a breach of the exclusivity agreement. So that 60 pages of typed notes on Microsoft Word notes document written by John Stokes, a Tipperary-based estate agent, is pretty important, and they were not discovered in the discovery process apparently, or were only discovered very late. He further claimed that this rolling note, that's what it was described as, had evidence of Mr. Regan bullying and threatening Mr. Stokes and threatening other Barne estate trustees. Martin Hayden said it was not the case that Mr. Stokes was bullied. He said the court would see in due course that Mr. Regan made several offers, €16.5 million, 18 million euros, and then 20 million euros for the Barne estate, but he received no engagement in response. Mr. Hayden, senior counsel, said, "If that's bullying, I'd like to be bullied like that." After 2 days of oral argument, Mr. Justice Quinn made orders for further discovery, directing the defendants, as the Barne estate people, to search devices belonging to key custodians for documents captured by previously agreed categories of discovery. And the case was adjourned to a date in April. A new date for the trial will be set. Fiachra Gallagher's reporting is in the Irish Times there, and that's what I'm relying on now. Now, there's a mistake in the earlier part of this video, and I'm going to correct that mistake, and I think it's very, very significant. I said earlier on, or I gave the impression earlier on in this video, that Magnier had an exclusivity agreement from the 30th of August, 31st of August 2023 until the 30th of September 2023, and then did a deal. And that's not the case. Because I read the report again, and I've noticed that the claim by Magnier, and this is crucial, absolutely crucial in my view, the claim by Magnier is that they did a deal first, that is on the 23rd of August 2023, and then there was an exclusivity agreement from 31st of August 2023 to the 30th of September 2023, that they couldn't entertain or encourage or invite or accept offers from anybody else. That was for the 1 month period. Okay, that's important, and the reason it's important is this. If Magnier had a deal on the 23rd of August 2023, if a deal was struck, why did he need an exclusivity agreement from the 30th of August or 31st of August 2023 to the 30th of September 2023? In other words, if I entered into a binding contract with somebody and I was satisfied I'd entered into a binding contract with somebody, I wouldn't need an exclusivity agreement thereafter, would I? Don't think so. I think that's important, but I wanted to clarify that because I did give the impression, I accept in the earlier part of the video, that Magnier had an exclusivity agreement and then did a deal. That's not the case. It seems to be, the reporting yesterday from Fiachra Gallagher in the Irish Times, it seems to be the case that Magnier is arguing that they did a deal on the 23rd of August 2023 and then entered into an exclusivity agreement from the 31st of August 2023 to the 30th of September 2023. And that, to me, quite frankly, is strange, is unusual, and is, I think, I'm only a small fella, sole practitioner solicitor in Enfield County Meath, I'm only a small guy, but that to me is a weakness in Magnier's case, simply because why would you need an exclusivity agreement if you had a deal done to buy the place? Maybe I'm completely wrong. Anyway, the evidence will show us all, and it'll be an interesting case which we'll have a look at and keep an eye on in due course. Hope you like the video. Hope you find the video useful. If you do, I would appreciate if you hit the thumbs up button down below. Thank you very much.